Darrell Brooks was back in court today, this time in Milwaukee. He still has to face those charges that he assaulted his former girlfriend, Erica Patterson. So, as expected, we had the unexpected in court today. Of course. He was very late, like 45 minutes late. You know, they have to transport him from wherever he's currently housed, which I think is still Dodge Correctional. Please correct me if I'm wrong. And he has to be transported from Waukesha to Milwaukee. And of course, you know, he throws his little tantrums and whatever. But today he was relatively calm, but it was still very late. So he was wheeled in his wheelchair. And if you remember from the last time he appeared in Milwaukee, he is in the wheelchair because they don't have restraints in Milwaukee that they can transport him and have him restrained. So, you know, they can't trust him to walk on his own, basically. So they have to put him in a wheelchair. Yeah, I know. So, very, very late. Okay, we see him getting wheeled in. There he is. He waves at the judge. The judge says hi. Now remember, he is in Milwaukee, so we don't have Judge Jennifer Doro. We have Judge Havas. And at this point, the volume gets cut, okay? So we can't hear anything. He's got a new hairstyle. And then, that's Judge Havas. And then we're staring at this painting for... It was a long time, like 15 minutes probably, okay? So, you know, everyone in the chat, of course, is like, what's going on? What's happening, right? So we do find out Darrell Brooks was brought in. He asked immediately to speak with his attorney because his attorney was appearing via Zoom. So, you know, you can't have a confidential discussion with a courtroom full of people. So Judge Havas cleared the courtroom so Mr. Brooks could speak with his attorney. And that's why we stared at this painting for a good 15 minutes.
State of Wisconsin versus Darrell Brooks, 21 CF 4596, 21 CF 502. Appearances.
Matthew Tarbinson and Shelley Grosso appear for the state. Good afternoon, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks appears in person. I appear via Zoom. Good afternoon, Judge.
All right. Good afternoon, everybody.
And here's little Mr. Brooks. So, as you heard, the audio is atrocious. And we are going to trial. Jury selection starts on Monday. That would be the 6th of May. We're starting jury selection, and they do discuss that a little bit in today's hearing. You know, how do you choose a jury who hasn't ever heard of him in the state of Wisconsin? It's very unlikely. So, but the audio is atrocious. Just a heads up, you know, I would keep, if you're wearing earbuds, probably turn them down a little bit.
Mr. Brooks first got here, my deputies alerted us to the fact that he wanted to speak with Mr. Jones. Given the fact that Mr. Jones is via Zoom and Mr. Brooks is here in person, the way we accommodated that was everyone left the courtroom, including the spectators in the gallery, the person who is here filming for the media, and obviously all the parties and my staff, except for the deputies. For security reasons, of course, they had to stay with Mr. Brooks. So I allowed them to have a conversation. I wasn't paying attention to how much time it was. It might have been, 15, 20 minutes. I allowed Mr. Brooks to have that conversation with Mr. Jones. And then after Mr. Jones alerted the lawyers, I think, and my deputies alerted us, we all came back in. Is that correct, Mr. Jones?
Yes, Your Honor. Thank you.
You're welcome. All right, so we are here it was supposed to be a motion hearing and a final pretrial on these matters. They are set for trial on Monday, May 6th, so that's just a couple days from now. At our last date on January 18th, the state indicated they thought they would be filing an amended information and an other acts motion. The defense also thought they may have been filing some motions, so we set this for about 90 minutes. I set deadlines for that all motions were to be filed by March 22nd and April 19th for the responses. I will note that nothing has been filed from either side as far as any substantive motions. Motions in limine were filed, I just believe, by the defense, and they appeared to be standard. So there is nothing to proceed on as far as any substantive motions. Do we remain in a trial posture, Mr. Jones?
We do, Judge. And with respect to the motion filings, we were anticipating potentially the state filing, and it would have been a response to the other acts. Presumably, they're not seeking that since they didn't file that. So that's why we had nothing else to file other than our standard motions.
Okay. And nothing from the state?
Correct. I anticipated filing another acts motion. I thought about it. The prejudice hurdle would be extraordinarily high in this particular case.
And by that, he does mean, choosing a trial. Like, everyone's going to be prejudiced against Darrell Brooks.
And when I gave it more thought, the state didn't anticipate using that other acts because of the prejudicial nature of those other acts, unless there was a defense that triggered the high amount of relevancy to those other acts. And I think that would just as likely happen if the door is potentially opened by one of those defenses being argued in this particular trial. And so rather than file the motion, if the defense becomes that this is an accident or some sort, then I may raise the issue at that point. So, but I did not file another acts motion. That's correct.
Okay. All right. So we'll deal with those issues if they arise during trial. Maybe they won't. So obviously we have some special issues associated with this case.
Look at him nodding. He's like, yes, I'm special. That's right.
Jury selection is going to be our biggest hurdle. What I have thought, just on my own, and I don't know if the parties have thought about this, I don't know if anybody would think that a court trial would be a preferable way to go to avoid any of those potential issues that would arise with having a jury and trying to seat a jury with a case that this case is not notorious, but certainly Mr. Brooks's other case is notorious. And we certainly will do our best to seat a fair and impartial jury. But that's just off the top of my head. I think that might be the best way, but of course, Mr. Brooks, that is ultimately his decision on whether it would be a court trial or a jury trial. So I just throw that out there. Nobody's requested that at this point.
So the difference between that is that the court trial, it would just be the prosecution, potentially Erica as coming as a witness, since she was the one who was assaulted, his ex-girlfriend. He would be there, all the attorneys would be there, and the judge would make the decision. So they can do that, and they're saying it's up to Darrell Brooks if he wants to have a jury trial, if he wants a group of his peers, quote unquote peers, deciding on the case, or if he just wants the judge to do it. So that's up to him, because he may not get a fair trial depending on the jury that's chosen. I mean, if you aren't familiar with Darrell Brooks, welcome to the madness. He was convicted of over 70 counts. There were people. If you're not familiar with the Waukesha Christmas parade incident, and on my other channel, depending where you're coming from this time, I made some videos about that, and a lot of you liked them. So I figure if I can, I'd like to cover this trial. I'm not sure if I'll be able to. We'll see. But I'll give you updates as we go, if I can.
Has been a request for a jury trial, so we will plan on that. But it is just some food for thought that it may be a way to allow for evidence to be presented without the potential tangential issues that would arise with a jury. So that's just something to think about. In addition to that, if I'm going to go on the assumption at this point that we are having a jury trial, I have not prepared any written information. I will prepare that over the weekend and give it to the parties, and we can certainly talk about it. But I think we have to address it. No one is going to pretend that we're going to introduce Mr. Brooks and no one's going to know who he is. So obviously it's not going to be, one of the standard questions I asked during voir dire is, has anyone heard anything about this case or about this defendant or had any opinion as to anything?
Now, I'm sure a lot of you, if you do come from watching these, court cases, and if you're interested in the subject in general, if you did watch some trials, you may be familiar with the term voir dire. If you're not, this is just simply the questioning of potential jurors. So let's say you get a jury duty notice in the mail, like you have to show up, you have to go. And the judge and the attorneys will ask you questions to determine if you can be an impartial juror, if you can make a decision based on the facts that are presented without allowing other things to cloud your judgment. That's what the process of voir dire is, to question all of the potential jurors to see, are they a good candidate to be on the jury? And each side gets a certain number of potential jurors that they can eliminate and say, no, we don't want that person. No, we don't want that person. So that's the process. And that's the process that's starting on Monday.
That may foreclose us from seating any of the people that we bring in for voir dire right off the bat, because it was a big deal. The Waukesha case was a big deal. So I will prepare something. Do the parties have thoughts? Or do you want to prepare something as well, and we can kind of put something together as far as a preliminary statement to the jurors? I mean, obviously advising them that this needs to be, you will only judge this case on this evidence, and, asking those questions if they can be fair and impartial and put out of their minds anything that they may know about Mr. Brooks. Each side can submit something if they would like. I'm kicking myself that I didn't think to tell everybody to do this ahead of today's date, so we could have worked it out this afternoon rather than doing it on Monday, but that was my error. I probably should have thought of that, and I did not. So if the parties want to do that, they can do that. I will have some language that I work up as well to address that. Other than that, I just talked with a sergeant from the Sheriff's Department. In the past, Mr. Brooks has been transported directly here and not really held in the jail, even as a waiting position, until he's brought directly to court. And then generally he's whisked away. I don't know what their plan is. I've got some concerns that if we're going to be in trial, I don't know what the situation would be in the jail, but I have alerted a sergeant in the Sheriff's Department to my concerns to make sure that Mr. Brooks is going to be here every morning for trial, that we're not going to end up with him being housed somewhere else. But I don't know that's not something that I get involved in generally. I did just want to put it on someone's radar to make sure that we have no delays when it comes to that.
And it is definitely a concern. One of the last times he appeared in Milwaukee in this court, it was a very late starting because, sometimes it depends what happens at the jail. If he's at Dodge Correctional, what time they come to get him, everything, driving there, potentially traffic, it's a distance. So, and that's if Darrell's being a good boy. And we know that that's not always the case. I mean, he's in a wheelchair for a reason. He's being shackled to that table for a reason.
Is there anything that, I think your motions in limine were pretty standard, Mr. Jones. So you've both tried many cases in front of me. Everybody knows generally how I run things and how things work. So I think they're standard motions in limine, so they were along with the rules of how I do things. Does the state have anything they want to specifically address on the record this afternoon?
Your Honor, the only thing that I want to address is I do anticipate filing an amended information. I have for a long time been very clear that if this proceeded to trial, that I would file charges of intimidation based on the calls that were made on particular days. And so I anticipate having a total of 6 charges for intimidation of a victim in the amended information. I will get that filed.
Once he was arrested for the Waukesha Christmas parade incident, he was calling Erica from jail, threatening her. So there are additional charges.
as soon as possible. But I have explained that both to Attorney Jones. I've explained that to previous counsel numerous times in communications on this case. I don't think that's a surprise to anybody. I think on the charge in the underlying domestic violence case, we are going to be proceeding on amended charge of first-degree recklessly endangering safety rather than second-degree recklessly endangering safety. So we will have those charges amended. And if the court wishes, I can prepare the jury instructions over the weekend, if that helps with regards to the charges.
Okay.
And then my only other question is, would the court prefer having information with both cases joined in a single information or having two informations with two cases? I can prepare it either way.
That is a CCAP protect issue that is above my pay grade.
Okay.
I think they probably need to be filed in each case. I'm looking at the back of my clerk's head, and she's indicating, yes, that would be better. So separate, for
Okay.
the separate cases. Mr. Jones, do you want to be heard as to what Mr. Torbenson's statements or your
Sure.
own issues?
Yeah, let me respond to Mr. Torbenson first, then I have a few things I'd like to address. Mr. Torbenson indicated if it does not resolve with a plea, he would file an amended information and bring all the charges he thinks that he can prove, and that's not news to me, and it's not news to prior counsel. I have requested for Mr. Torbenson, I know I have it in writing somewhere, but I've made a request of him to put his offer in writing because Mr. Brooks wants it in writing in an email, so you could just send me one today with that discussion. Mr. Brooks had some issues with potentially discovery at basketball. I'm going to provide him written or all paper discovery that I physically can get my hands on and give it to him also Monday, even though we sent it to him back in March. And I'm not saying Mr. Brooks is wrong. I'm sure the institution may have lost it, but we can deal with that. I have it all. I'm prepared.
So when he refers to discovery, he's talking about the evidence that's going to be presented by the prosecution. That is a requirement that it's shared with the defense team. So his new lawyer, he's been through a couple, is saying that they were sent to him. And, Darrell Brooks is saying he didn't receive it. And, he's very gracious and saying, I'm not saying he didn't, we don't know really what happened, but we know from his prior antics that, he might have received it. He might have flushed him down the toilet. Who knows?
I have two requests. Number one, I think given the nature of this and the panel and the background, it would make sense if we started maybe at 9 o'clock. I have two quick appearances at 8:15 and 8:30 that I'd like to clear off. If we come in at 9, obviously I think if the three of us get together and decide how to deal with a joint statement, and I would prefer it to be issued by the court rather than the state or me, I think we could accomplish that in probably about a half an hour's time. The other thing, I'm going to make this request, and I don't know how much the court has the authority to do this, other than that you can make a request to the jail, but your request would probably be received better than mine, even though I've made inquiries. I know, or at least I've learned now, Mr. Brooks might be moving back and forth to the institution. I understand we can't control that. If at the end of every day of trial, I can have a deputy keep him in the bullpen for some period of time, half an hour, so I can at least meet with him in the bullpen, or if we can break at 4:30, so we can have someone till 5 o'clock, so I can have some time with Mr. Brooks after each day of trial. It may not be needed. I might say, hey, today that we don't need it, but I'd like that little bit of cushion because he's going to be physically removed, and I won't have the opportunity to do that. So maybe we break a little bit earlier than we normally would, so I would have that on days I might need it. Just sort of thinking ahead.
Sure, I think we can accomplish that.
Reasonable.
So I want as much communication with Mr. Brooks, obviously, as possible, but I understand I'm bound by the executive, the executive branch and their whims.
Judge, it's probably too late for this as well, but I'm just taking in the size of your courtroom physically, and I'm wondering if there's any chance we could switch courtrooms just for jury selection even, because I imagine we're going to have a rather large panel for jury selection.
What I anticipated doing, and I think it probably is too late to plan a switch now.
I mean, let me get her on a better face. Yeah. I mean, Mr. Torbenson, okay, he's prosecution, all right? Are we just now looking at the size of this courtroom? We've been in this courtroom with Mr. Torbenson, a couple times now, and he knew that this was coming up, and this is Friday, and jury selection starts on Monday. Courtrooms are already booked. So, I don't know. It sounds like he's trying to be helpful. It doesn't sound helpful to me, though.
What I would anticipate is I can get 35 in. It's tight, but we can do it. So we can have 35 people in here. And then if we are able to, let's say, seat 8 out of the 35, we will put them back in our jury room and bring a fresh panel of 35 over and do it in that way. I don't have any idea how long this is going to take, given, as I said, the notoriousness of the Waukesha case. So I wouldn't want to guess that one of the bigger courtrooms is going to accommodate it and it still doesn't, and have everybody move for those purposes. So I think we just kind of get as many as we can and then start with a new group. So it may take longer than usual. So we may do a couple process of picking a jury in piecemeal fashion. But we should be able to accomplish it in that way. I think if we do run into issues, that may be the best way. So what I'm hearing from everybody is Mr. Torbenson has offered to put together the jury instructions. I appreciate that. And we will all work on what our idea of a statement looks like as far as what to tell the jury about this case, and that it is only this case they are to determine. Not anything else they may have know or heard or think or believe they know or any judgments they've made. And we will question people about that specifically. It's not going to be a general run-of-the-mill, I assume you haven't heard anything about this. You haven't? Yeah. So we will take it from there. So everybody's going to bring that statement, and Mr. Torbenson's going to do the jury instructions. Is there anything more from the defense?
Yeah, and Judge, I have a scheduled meeting with Mr. Brooks tomorrow at 2:30. Apparently that's not going to occur because he won't be at the jail. I'm efforting to get a meeting with him at his institution
I don't know that for sure.
Well, Mr. Brooks is fairly confident of that. Either way, I've got the one set up at the jail. I'm going to try and set up the one at the institution, and hopefully, one of them occurs.
Okay.
And if he can be brought over at 8 a.m. even, I will try and get down there. I mean, I'm just saying, once he's in your bullpen, I think that's, a place that makes it easier for me to get to him. But we'll stay in communication and do what we can, I guess.
Okay. All right. Anything further from the state?
The only thing I want to add is that
Okay, so now, right? There are a lot of bad omens, okay? So the live stream is now offline. You see me checking it like, wait a minute, what happened, right? Live stream offline. So the channel who was streaming this, they go and they reset it, they have to reset it. So we're just kind of like waiting, like, what's going on, right? Here we go. So, and it looks like they were streaming it. Just curious. I want to look for myself. So they're streaming it from Vimeo. Yeah, state of Wisconsin, MKE County, Vimeo event. Interesting. Okay. So we might go directly to that next time. We'll take a look. So they reset it.
Get to him, but we'll stay in communication and do what we can, I guess.
Okay. All right. Anything further from the state?
the only thing I want to add is that I did tell the court and counsel and chambers I have a homicide case.
And now Darrell's lawyer is gone. This does not bode well. Court clerk is like on the phone, like, ah. When you see these reflections that are going in front of us, we're behind glass, so that's why. You can actually see a woman sitting right here.
The internet. I can't hear. What? The internet? Oh. Okay, so it's just the internet's down.
The internet went down. Great. Great. Now, I do wonder about this this county courthouse. The furniture is, I mean, it's really old. It's really beaten up. And their internet goes down in the middle of a hearing. And Darrell's just patient. He might be medicated. I don't know. He does look extremely calm. Hair looks nice. I'm glad he got rid of all the braids and everything. Although, I don't know, the shaved head looked kind of good too.
It says an unknown error, so now it's letting me start again. Let's see if Russ pops up.
And these courtrooms never have decent tech support. Like, there's never anyone there that knows what's going on. Hardly ever.
In case the record isn't clear, we lost Mr. Jones via Zoom.
He's in the waiting room.
Well, we're still connecting.
Watch this. This is good.
Hi, you're back.
I can see you.
Yes.
You're
Muted,
muted.
Judge.
I don't know if you can hear me.
Your mute is on.
Oh, thank you.
Oh my God. Whenever I see something like this, right? Like during the pandemic, pretty much everybody, I would think, learned to use some kind of streaming, some kind of like video share, like Zoom or even Skype or something, right? And it's like we still, to this day, so many people don't know how to use Zoom. Still, so many people remain muted. And here's Darrell Brooks. Okay, Darrell Brooks, he doesn't look like he's scheduling meetings from his cell or doing anything on Zoom, but he notices before the judge does, you're muted. And he says it very politely. And she says, "Oh, thank you." And he's like, "You're welcome." Let me just play that again. That was my favorite part of this whole hearing.
Yes.
You're
Muted,
muted.
Judge.
I don't know if you can hear me.
Your mute is on.
Oh, thank you.
You're welcome.
I automatically ended up muted, but Mr. Brooks pointed out to me that I could unmute. So now we can hear
Yes.
you and you can hear us.
You're back.
All right, so
The last thing I heard was Mr. Torbenson saying he has a homicide trial, has an emergency stay, and then he froze.
right.
I think it's unlikely for the stay to be lifted, and this should be the case that can go on Monday.
Okay. All right. All right, then I think we just stand ready to go on Monday, barring something else happening. Mr. Brooks, I don't know where you're going to be, but I look forward to seeing you on Monday. Mr. Jones said.
And this is where the live stream ended. It just froze and ended completely. So we'll see you perhaps on Monday for jury selection. We'll see how that goes. All right, stay tuned. Talk to you soon.